Joining me now, my friend Josh Hammer, host of America on Trial. Josh, okay, Trump is immune. Woohoo! Sounds great. How immune is he, Josh?
Well, that kind of is a million-dollar question, Jesse, and the Supreme Court doesn't fully answer that question today, but this is basically as big a win for Donald Trump as could have been reasonably possible under these circumstances. So, not to toot my own horn, Jesse, but I guess I'll do it a little bit here. On America on Trial with Josh Hammer for basically the past 2-3 months, I've been predicting essentially this exact outcome, which has been largely what most right of center court watchers have been predicting, which is they say that there's no such thing as full sweeping immunity for literally every single thing a president does in office. So there's not going to be an absolute victory for Donald Trump. But on the other hand, Jack Smith's claim that there's no immunity is farcical and laughable. So both of those extreme claims lost. It's generally a win for Donald Trump. This is the best case scenario of all of the outcomes that were possible. So what they basically said is that for core Article 2 constitutional function duties, for all core constitutional acts, a president does have absolute immunity, period, full stop, end of story. So we're talking here about commander-in-chief clause, use of the military, appointments clause, where you're hiring a new cabinet secretary or you're firing an inferior person deep down in the bureaucracy. When it comes to hiring and firing personnel, commander-in-chief, military, absolute immunity. No one can possibly bring charges after you're president for that. Then there's a lower tier for acts that are in his official duty but aren't core constitutional functions. One example would be the kind of act that the president shares with a different branch of government like the Congress. This, according to Chief Justice John Roberts, is where January 6th falls into. So, for example, the president's coordination, or rather his communication with the vice president, Mike Pence, leading up to January 6th, this would be part of his official duties because he obviously has the official duty to communicate with his vice president and to push his agenda through the Senate. And the vice president is the president of the Senate under a constitution. So for these official acts that are not core constitutional, you have a rebuttable presumption of immunity, meaning that we presume there's immunity, but the other side can make an argument before the judge trying to overcome this threshold. So Jack Smith's going to have an uphill slog back in district court to prove that anything January 6th related is prosecutable. And then, as we predicted, there's that third bucket, Jesse, as well, where there's unofficial acts which get you no immunity at all, which, again, I won't toot my own horn too hard, but that's what I predicted and what many others predicted as well.
Okay, so walk me through this as best you can, Josh, and I will give you the floor. We all know Trump's getting sentenced, I believe, in a couple weeks in New York City. So there's that. There's the Jack Smith stuff. Now, you said he has an uphill slog, but it's up to a judge. I'm assuming a judge from the filthy D.C. District Court. And then there's the Fani Willis stuff, if that stuff's still going on. And there's the document stuff. So there's a lot of different things. So where does this ruling, how does it pertain to any or all or none of these things?
Yeah, great question. So let's take it one by one then. So the New York case does not have anything to do with what happened today because the hush money case is all pre-presidential conduct, the so-called hush money stuff. So nothing that happened there was implicated from today. Now, the sentencing is coming up July 11th. Trump will get his shot on appeal there. There's all sorts of glaring constitutional problems there. I see a 6th Amendment issue, a 14th Amendment due process issue. There's a lot going on there, but today's ruling does not affect that. The Georgia case, it actually does. Because the Georgia case does pertain to his phone calls that he made, including that phone call to Brad Raffensperger, the Secretary of State of Georgia, on January 3rd, 2021. Now, this likely is in that murky second bucket. So, for example, that phone call from Trump to Raffensperger would be an official act, but likely not a core constitutional act. So that's going to ultimately have to go back to a lower court for fact-finding as well. Recall that the Georgia trial is currently on hold for now. They're not going to have anything to do with that until October. So that's very much kind of on the back burner right now. We're trying to figure out whether or not Fani Willis can even stay on the case. That's where we are right now. But there are some possible ramifications for this ruling in that case. Now, perhaps the most interesting part of today's ruling at the court, at least to me, Jesse, is this wonderful concurring opinion from Justice Clarence Thomas, parts of which John Roberts echoes in his majority opinion, which calls into question the legality and the constitutionality of Jack Smith being a special counsel in the first place. Which, by the way, Judge Aileen Cannon has been screaming from the rooftops about this for months now. She held an evidentiary hearing on this very subject about a week and a half ago. And the liberal media has been screaming at her, oh, you're just a Trump lackey. This is a crazy claim. How can you have a hearing on this? Well, Clarence Thomas, and to an extent, really the majority opinion, now provide ample support there. So I think Judge Cannon is probably going to have to double down in the classified documents case and really kind of prolong these hearings as to whether or not Jack Smith has any business whatsoever bringing these charges. Is there a statute that gives him this office? Did Congress create the special counsel's office in the first place? These are very real and legitimate questions. And, if Judge Tanya Chutkan in D.C., pertaining to the other Jack Smith probe, if she wants to do her job, then she will go ahead and entertain those questions at the trial court level as well. She's a bit of an anti-Trump hack, so I'm not sure if she will. But you look at all of what I just said, and then you combine it with the Fisher case that came out on Friday pertaining to the J6ers, because 2 of the 4 charges against Trump in the Jack Smith D.C. case, 2 of those 4 charges pertain to the same statute that the court just narrowed in the Fisher case. Jack Smith is really bad, dude. I mean, Jack Smith has now had 2 horrible, horrible days at the court in a row. He's probably got to be considering a different profession, if I had to guess at this point.
Gosh, that's wonderful to hear. Okay, so let's talk about those J6ers who are rotting in prison. Are they getting sprung, Josh? Are sentences being reduced? Any of them? All of them? How does this recent Supreme Court ruling about that, how does it pertain to them?
So every single J6er who has been prosecuted or is being prosecuted or has even had a sentence come down already pertaining to this particular provision now has a very viable legal claim to either get their prosecution tossed out, if they've been sentenced, to get their sentence reduced on the back end, or various other remedies like that. If they took a guilty plea deal, then they can now make a formal motion to revoke that formal plea deal because the basis on which they've been charged has been deemed illegitimate. So they're going to have all sorts of legal options. Now, Jesse, it's worth pointing out the Department of Justice put out this kind of ridiculous press release over the weekend. I think they put it up on Saturday, essentially telling the American people, look, the Fisher case, not a huge deal. Yes, like 30-ish, like roughly 30 J6ers. We've been prosecuting them under this particular statute. But don't worry, most J6ers we've been prosecuting under a lot of different statutes there. It was a very kind of gaudy and supercilious press release from the DOJ. I kind of hated reading it there. But I guess to the extent that they're right, then yes, I mean, the J6ers who were not prosecuted on this specific statute, they're likely not going to have a huge effect. But there are a bunch of J6ers whose claims, when it came to the Fisher underlying statute, they're going to have now a real case to have a sentence reduced at a bare minimum. And again, it looks to me like 2 of the 4 charges against Donald Trump in his D.C. case, if we're going to have an intellectually honest judge, which we might not have that in Tanya Chutkan, but an intellectually honest judge would probably toss out those 2 charges at a bare minimum.
Yeah, well, I won't be holding out for Tanya Chutkan to do the right thing, that's for sure. Okay, I can't let you go without digging into this Chevron thing, because honestly, between the debate and all the other stuff, Trump kind of is overshadowing everything, as he's wont to do, just because he's Trump. But the Chevron case may have more to do with saving the United States of America than anything that it has to do with Donald Trump. What was this about?
Yeah, so Chevron deference has been a long-standing white whale of the conservative legal movement, essentially since I started law school. I mean, even before that, really. But, for as long as I've been in the conservative legal world, Jesse, this has probably been just below Roe versus Wade and affirmative action and maybe 1 or 2 other cases. This has been a long-standing priority. So Chevron deference takes its name from a case called Chevron, obviously, from the mid-1980s. And what they basically did was they made an appeal to judicial restraint, and they said that when Congress legislates a statute using ambiguous language, then the agency has a broad swath of leeway, of legroom to interpret the statute in a way that is reasonable. So if 1, Congress writes an ambiguous statute, and 2, the agency's interpretation of that statute is reasonable, then the courts have no say. They just can't weigh in, and the agency's rule is what it is. Now, this may have made sense back in the 1980s, back when the Reagan administration was trying to undo the Jimmy Carter era, trying to undo 30 years of judicial activism from the Warren Court. The problem with Chevron is that it's just a blatant violation of the separation of powers. So Marbury versus Madison, 1803, where John Marshall gives us judicial review for the first time, he famously said, quote, "It is emphatically the province of the judiciary to say what the law is." And it's true. That is the role of Article 3 of the judiciary, to say what the law is. So you can't then just invent a rule that prohibits the judiciary from saying what the law is. So the practical effect of overturning Chevron, which is long overdue, is that the administrative state is going to have much less power to interpret its own statutes, and the courts are going to be more hands-on and more involved. So that should be a very good thing in the mid to long term when it comes to reducing and ideally fully deconstructing the behemoth that is the modern administrative state.